Thank you, Yoshinobu. It's wonderful to have you here in Alicante today. Please remember, those who are following us, if you want to follow the English channel, you have to select the English channel. And if you want to follow us in Japanese, you have to select the Japanese channel. So let's talk a bit about the EU-Japan trade, which is quite remarkable. We represent together a population of over 570 million people, and we account for almost a quarter of the global GDP and almost 20% of the global trade. And this is why it is very important to bear in mind the importance of protecting your intellectual property when you start trading in the other jurisdiction. Given that our trade is quite remarkable. So a few words about the importance of IP protection. We ran a study about what it means for a business to have intellectual property protection. And it resulted that almost 40% of all employment in the EU can be attributed directly or indirectly to IP-intensive industries. And there was a positive link between owning IP rights and economic performance. If your business owned an IP rights, the revenue per employee was 55% higher. And those who own at least one IP right have at least 68% higher revenue per employee. At the same time, you have 1.5% chance of surviving in the long run if you don't own any IP rights. And we also noted that, at least in Europe, about one in every 10 small businesses is the one that owns any type of IP rights. So it is important to bear this in mind when you're revising your business operations. 93% of SMEs who have registered IP rights have seen a positive impact. The long-term business prospects are about half times better. It is much better if you are registering an IP right. Sorry. Yes, Yoshinobu, can you please say a few words about why it is important to protect your intellectual property?
Yes.
Thank you very much. I'd like to now take a look at why intellectual property is so important to us. First of all, obtaining patent rights is a significant advantage in making a company attractive to investors and funds. And the second point, in the B2B market, it will allow you to gain a competitive edge. For example, large companies may prefer sustainable suppliers for their ESG goals, and by demonstrating sustainability, can manage to open up market access. And thirdly, by acquiring intellectual property rights, you can gain an exclusive position in the market. Number 4, you can enhance your reputation and gain customer loyalty. Let me give you an example. If you are able to establish a brand image as an eco-friendly company, it can lead to acquiring loyal customers. And fifthly, intellectual property in and of itself can be a source of income. This can take the form of exclusivity, licensing, sale, or even franchising. These are opportunities for added income. And sixthly, intellectual property can help protect your business through legal action. So in this manner, intellectual property protection is a powerful tool in the market. It will allow you to demonstrate to customers that your company is unique, innovative, and legally protected. In markets like the EU and Japan, where consumers value innovation and quality, this advantage can lead to increased sales and brand recognition.
And what are the risks of not protecting your IP rights?
Yes. And 次に、知的財産を登録しないことによるデメリット。
So, what are the disadvantages to not registering intellectual property? Let's take a look. Firstly,
融資、補助金、
Without registration, you may lose opportunities to obtain loans, subsidies, and funds. And secondly,
他者によってアイデアを盗ん
your
で
ideas
されてしまったり、
may be stolen and registered by others,
されてしま
or your company's logo may be registered as a trademark.
う面につきまして
And thirdly,
登録されていない
there is a
財産権を他者が勝手に使用してし
a
まう
risk of loss due to others using unregistered intellectual property rights without permission. If intellectual property rights are not registered,
他権にのみに頼る
you will only be able to rely on limited rights that do not require registration. And fourthly,
ブランドの
it affects the distinctiveness and reputation of your brand.
ですが、
And lastly, number 5,
自社の権利を守ること
in the event of a legal dispute, it would become very difficult to protect your company's rights.
が高額な訴訟費用が必要
Legal disputes also require high litigation costs.
So, can I please ask who owns IP right among the audience? If you want to raise your hands. What is important to know is that your IP rights are not valid. If you own IP rights in Europe, it will not be valid in Japan. And if you own IP rights in Japan, it will not be valid in Europe. IP rights are territorial and they are confined to one jurisdiction. So it's very important to consider intellectual property protection as soon as you start trading with the other jurisdiction. It's also important that you identify all the assets you have that can be valuable and can qualify for intellectual property protection. For example, you have to check your products. Do they have any unique features? Do they have any functionalities that are unique? Any designs, any branding? Check the technologies that you use. Maybe they are new, they use inventive technology. Maybe they have some branding elements that identify your business and it will help your customers to find you the next time they want to repeat the purchase. Check all the communication, social media, websites to identify any logos, slogans, packaging designs, advertising campaigns, promotional content that would appeal to your customers. Identify any distinctive branding elements, any digital asset. Check your paperwork to see if there is any intellectual property that you already own that was created by your employees. Check if there are any confidential informations detailing your product development process. So basically, you have to make a list of all this because all these are intangible assets that can generate value for your company. And Yoshinobu will say a few words about the different intellectual property that can be used to protect these assets.
はい。それではどのような知的財産権があるのかを簡単にご説明させてい
Then
た
I
だ
would
きます。
just like to go over the types of intellectual property that can be protected. First of all, let's look at patents. Patents can be obtained for inventions in various technical fields. An invention is defined as a highly advanced technical creation that utilizes the law of nature, and that is how it is defined.
特許を得られる発明
And furthermore,
新規であること
an invention eligible for patents must be novel, progressive, and industrially applicable. So these are the requirements. And as for industrial applicability, let me provide some examples. For example, surgical, medical, or diagnostic procedures for humans
また個人学
will not be covered.
についても
And also for anything that has to do with experimental activities that are personal or otherwise academic as well, these will not be eligible. And also activities that are clearly impossible to perform, such as covering the entire Earth, will not be eligible. Now let's look at utility model.
実用新案については
Utility models are similar to patents,
基準が設けられています。
and similar criteria are in place. But unlike patents,
対象が物品の形状を通
the protection is limited to the shape of the article, and the protection period is half as long as a patent,
図面を提出
10 years, and drawings must be submitted.
また権利を得るプロセスにおいて
There's also a major difference in the process of obtaining rights. There's the absence of the substantive examination, but instead, when enforcing your rights, you will need to obtain a utility model technical evaluation report form from the JPO. Due to these characteristics, the utility model system is well suited for protecting products with short life cycles. Now, I'd like to go over the trademark. Trademarks indicate the origin of goods and services and helps to maintain a company's reputation. Text, graphics, logos are registered. In the case of Japan, these types of trademarks can also be registered, that is, motion, sound, color, and holograms can be registered as a trademark. On the other hand, there are those that cannot be registered: smell, taste, and touch. These cannot be registered as a trademark. And next on design. Designs protect the appearance of an article. In Japan, images, buildings, and also interiors can be protected. These intellectual property rights require application and registration. If you publish information before filing the application, you will no longer meet the novelty requirement for registration, so there needs to be attention here. There are also some rights that do not require registration, one of which is the copyright. Copyright protects the creative expression of thoughts and feelings, be it documents, music, paintings, videos, computer programs, databases. These can be protected. And how about trade secrets? Trade secrets refer to economically valuable information that is kept confidential, such as manufacturing methods, sales methods, and customer information. Maintaining confidentiality requires particular care. Trade secrets are protected under the Unfair Competition Prevention Act.
Thank you very much, Yoshinobu. Now let's turn all this theory into practical examples. This is an example of a car interior which has all sorts of intellectual property protection available. For example, you can protect the technology of the self-driving technology. You can protect it as a patent. And you can protect the trademark of the car, the brand, that the consumers will find and repeat the purchase of the same car usually, because most people are very loyal to their cars. And then the design is very important for cars, so this is definitely worth protecting as a separate intellectual property right. You can use copyright protection to protect, for example, the software that you use for certain functions, and you can protect even some of the marketing material under copyright. And if you have anything in the development process, then you should consider trade secret protection and to keep it as secret as possible, and to make sure that your employees are aware of the importance of keeping this as a secret, and conclude non-disclosure agreements to feature it in the contracts, in the distribution agreements, everywhere in the manufacturing process. And once you decide that the development, the product is ripe enough to be disclosed to the public because it's new, it has an inventive element, and it's applicable for industrial use, then you should consider protecting it as a patent, bearing in mind then that this will be available, this technology will be available for everybody else. Yes, Yoshinobu, I think you will talk a bit about this overview of the different IP rights.
Yes. はい。それでは、知的財産権の、概観をまと
Yes,
めました。
this is an overview of the intellectual property rights that I would like to cover.
各権利の権利期間、有効な
This summarizes the duration of the right, scope of validity, and whether or not it is registered. patent trademarks and designs
都庁での
are registered with the JPO, Japan Patent Office,
地域でのみ
and are valid only in the region in which they are registered.
期間は20
The
年
validity period for a patent is 20 years. The validity for a trademark is semi-permanent as long as it is
25年となっております。
repeated. And the registration period for a design is 25 years. Each of these will need to be updated at the designated time, so please bear that in mind. Trade secrets are not registered. Since they are not registered, there are no geographical restrictions either.
盗まれないように
To prevent trade secrets from being
盗
stolen,
まれた場合に訴訟に備えるため
and if they should be
に
stolen,
残して
we need to prepare for lawsuits. And hence, it becomes necessary to document their existence and maintain
必要です。
their confidential status.
Thank you, Yoshinobu. Yes, it is indeed very important. I have another slide about some of the key factors and about some of the differences. It is very important, as you said, that there is a limit to intellectual property protection. You can get 20 years of protection on patents and 10 years on utility models, 10 years on trademarks, but trademarks can be renewed indefinitely. And we both have 25 years on designs. Once again, it's very important to bear in mind you have to protect your invention or your technology or your trademarks in the jurisdiction where you would like to do business. And you also have to consider if you will do direct filing in one country or if you consider international filing if you want to do business in different jurisdictions. And you have to bear in mind as well the priority. For example, once you have a technology and you disclosed it, once you file the trademark in one jurisdiction, you have 6 months to file the same trademark in a different jurisdiction and keep the original filing date. This is very important. Once you decide to file in a trademark, you have to remember to this 6 months cutoff. And also you have to remember the grace period. Once you disclose your technology, you have 1 year to be recognized as the inventor. And it also goes for designs. So please bear in mind this 1 year, which you can take advantage of the intellectual property protection and the exclusive right confirmed by the intellectual property to market your product. There are some differences between European Union and the EU IPO and Japan. For example, in Japan, they do ex officio examination of earlier trademark rights and design rights, and we don't do this at the EU IPO. For patents, we do ex officio examination of prior existing technology, both in Europe and both in Japan. And for copyright, none of our jurisdictions require registration. They are created just upon creation. Let's see, Yoshinobu, can you say a few words about how long it will take to register your intellectual property right?
はい。それでは、審査結果が得られるまでの期間についてご説明させていただき
I'd
ます。
like to talk about how much a period is required from filing to registration. This is data from 2023. For a trademark registered in Japan,
7.3 月で結果が得られております。
it has to require 7.3 months. EU IPO 4 months.
では、6.8 月
And for design, 6.8 months in Japan.
では
EU IPO, 0.7 months.
おります。特許については、
For patent,
13.8
13.8 months in Japan. EPO, 24.9 months.
また追加情報としまして、
In addition,
特許については
for
早期審査
patent,
とスーパー早期審査というオプションを
accelerated and so-called super accelerated patent examination options are offered free of charge. The time it takes to receive the review results
短縮されます。
can be shortened to 5.1 months
を利用しますと
for accelerated, and for super
短縮されています。
accelerated can be shortened to 2.4 months. In addition,
まとめ審査
Japan offers an option for what is called bundled examination.
商標の
This allows for a simultaneous examination of applications that bundle patents, designs, and trademarks to obtain examination results at the same time.
The examination time between for trademarks and designs, it's also the difference of the different examination methods that at the JPO you do ex officio examination of earlier rights. At the EU-IPO we don't do it, so this is why we can be much quicker. I will say a few words about how long it takes, how much it costs to have registered IP rights. For trademarks, at the EU-IPO, it cost 850 euros. And at the JPO, it cost 3,400 yen plus 8,600 per class. It's about comparable. For designs, JPO is much cheaper. 16,000 yen versus the EU-IPO's 350 euros. And for patents, once again, Europe is much more expensive. At the JPO, it costs around 14,000 yen for the application. And then you have some other fees for examination, for publication opposition, all that. At the EPO, it costs around 6,800 to register your patents, everything included. Yoshinobu, I think you have some information about how it's cheaper for small business to register in Japan.
Yeah. はい。それでは日本では特許につ
In
い
the
ての
case of
制
Japan,
度がありますので、
there is a system of exemptions and reductions for patents
審査請求料
for certain applicants.
維持費につきまして減額
Examination fees and patent maintenance fees will be
こ
reduced.
ちらの表のありますように、
And as you can see here,
スタートアップ
for small and medium-sized companies, startups and universities,
減免され
and other similar organizations are eligible. The amount of reduction will vary depending on the applicant's economic status, research and development capabilities.
We have a similar system, the SME fund, where you can apply for the reimbursement of some of the costs that you paid for your application. For different IP rights, but we have an entire separate webinar on this, so I will not talk about the SME fund in detail. Please check out the other webinar we have on the subject. It is available on the EU-Japan Intellectual Property Action website. And also there is a link here for further information on how to take advantage of the SME fund. Now, let's go back to the beginning. You have identified your IP assets. You decided which is the most suitable for you and how you want to, where and how you want to protect it. You are also aware now of what the costs are. You have to check as well if you're not infringing anybody's intellectual property rights. You can take advantage of representatives, or you can also make your own search. And for this reason, there is a list of all the search tools that are publicly available that we are providing, that the JPO is providing, the EPO is providing. So you don't need a representative to check. If there is an IP right out there that is already taken, then you shouldn't bother with trying to protect it. Yes, you also have to bear in mind that for example, a trademark, it can be offensive in some jurisdictions, or it can be just basically descriptive. It would describe the goods to such an extent that it would not qualify for trademark protection, and then it shouldn't be registered. Yes, you have to bear in mind for the technology, you have to make sure that this is completely new, that it's not registered before. And for that, you probably will need a qualified representative who is aware of the technology. With all this, there are some more considerations that you have to do. You have to document everything that you do. You have to document the creation, especially if it's a technology. It's very important that you have thorough documentation of everything that is happening in your company, because you own basically everything that was created by your employer. All the technology, all the design rights, it belongs to your company. But for that, you have to have clear the employment contract situation, the subcontracts, the assignments, You have to have documented, if you acquire a new IP right, you have to have the contractual situation clear. And you have to have copies of invoices, orders, websites, because, for example, trademark rights, they need to be used both in the EU and in Japan. And in the EU, up to 5 years of non-use, they can be cancelled. And in JPO, I think it's 3 years. That after 3 years, it might be cancelled if a competitor decides that this is not used and they would like to apply for a similar right. So please make sure that you document all the use of your intellectual property right. You have to sign confidential agreements, non-disclosure agreements for trade secrets. And then if that IP right is already taken, you have to make sure that you conclude the proper licensing agreements. And for example, if you go for a trade fair with your design, with your technology, that can also qualify for intellectual property right. If it is the first time you present it in a trade fair, but you have to make sure that you take a picture of your booth, you take a picture of the technology, and you document all this to make sure that that everybody knows that you were the first, and this was the first appearance of your product on the market. Yes, I think this is. I think Yoshinobu will say a few words specifically about licensing, which is very important. If you already own an IP right, for example, in the EU, and you would like to take it to Japan, but it's already taken in Japan, so you might want to consider licensing. Yoshinobu, please.
それではライセンスについて
Yes, I would like to talk about licensing.
中小企業などの事業者の皆様に
For those of you in the SME,
知的財産のライセンス
when it comes to licensing
過小評価されている
opportunity in a new market,
ライセンスは
there might not have been ample attention made
で
in
安価で
using intellectual property. It would be the low risk and also the cheapest means
まだ自社が知られていない
to exploit IP, and it can provide the small and medium-sized enterprises with a power presence in a local market, often unknown to them. Before licensing
まず1点目と
is done, there are some prerequisites. First of all, make sure that you have a clear ownership over your IPR and a valid registration when needed. And secondly,
注意深く選ぶようにしてください
choose your local business partner with caution. And thirdly, in the agreement, define the scope, exclusivity, royalty, and responsibility very
1
clearly.
点目につきまして
And
その開始前には
fourthly, before licensing,
税制執行
analyze
など
and take into account
財政的
the
な
legal
を分析するようにして
and financial risk, for example, under competition law, taxes, and enforcement. And just to reiterate, when you license your intellectual property in Japan, whether it's a patent, utility, model, design, or trademark, that license must be registered with the JPO to be enforceable against third parties.
保持しなければなりません
And for trade secrets, it must be managed as a secret.
証明やタイムスタンプを
It is also important to document and secure proof of existence
存在を確
of
認
a trade secret by, say, electronic fingerprint and time stamping.
契約雇用契約
And through contractual clauses, for example, NDAs and employment contract or partnership agreement, it is important to include a clause,
機密性のある
and that would be a good practice to safeguard your intellectual property. If you're sharing sensitive information with a Japanese partner or a team, make sure you put that contractual protection in place from the start. In Japan, legal protection is available under the Unfair Competition Prevention Act. When a trade secret is misappropriated, a civil claim can be brought.
Yoshinobu, indeed, it's very important. Once you decide to go to Japan to do business, it's very important that you get some local partners and you establish trusted relationships with Japanese subsidiaries or partner companies. Let's talk a bit more about best practices once you have intellectual property protection, it's important that you communicate, that you make your partners aware that you have intellectual property rights. First of all, it's important because, for example, in Japan, also in the EU, we are an advanced economy, and we place a lot of confidence in intellectual property rights, which somebody already decided is worth the investment. So it's important that you meet a new business partner and you tell them that you have already a registered intellectual property right. You can put it on the product as well if you decide to market it. For example, in the EU, we have this new thing called the D mark, which you can put on your registered design. It's not an obligation, but it's completely voluntary, but it is very much advised to take advantage of this because it sort of increases the value of your design application, that you can show that it is something that was worth investment for you as a registered design. You can also put in the TM, the copyright, the register, all the marks that you can take advantage of that can show the partners that you have some intellectual property protection would be welcome. Also, it is important, not just for your representatives, but this is something you can do yourself, especially if you're a small business. You monitor your intellectual property rights. You follow the websites, the social media, the search engines. You especially monitor the competitors and the partners' behavior, because sometimes you have distributors who decide to go rogue and basically use your IP rights or register your IP rights in other jurisdictions. So you have to take this into consideration. And then once you see that there is some infringing behavior, counterfeit or anything fraudulent coming up, popping up on a website, it's important that you act yourself. You don't wait for authorities. Maybe you can download the cease and desist letter if you see somebody's using your intellectual property right. You monitor the social media to take action. For Google Ads, for Amazon, all these things, you have your own tools to take action if you see fraudulent behavior. And in the worst case scenario, you have to go to court and you have to file, for example, an opposition if you see somebody else applied for your intellectual property. But all this requires time and effort, and you have to bear in mind the importance of also enforcement. Yoshinobu, you have some slide about enforcement?
Yes. はい。それでは、日本では取り締まりについても有効
In the case of Japan, enforcement have also been very effective.
3万の事件以上が
There are more than
ています。
30,000 cases which are seized every year at the Japan Customs Office. And when you look at the chart to the left, there are some changes at the border control.
について
In the past,
輸入や販売が禁止されていました。
there have been prohibitions to export and import by Japanese companies. However, in 2022, sending counterfeit goods to Japan by mail or other means by overseas company has also become an infringement of design rights and trademark rights. Furthermore, the act of a Japanese individual purchasing counterfeit goods from overseas and importing them into Japan also constitutes an infringement.
And we have something useful for companies to bear in mind in terms of enforcement. The EU IPO operates the IP enforcement portal. So if you bring some goods into the European Union, or you trade something in the European Union, and you want to make sure that your intellectual property is properly recognized, you might want to upload it in the IP enforcement portal. You can register your products here, and this way there is a direct access for customs officials to identify that this is your product. And this is also a very useful portal where you can file customs declarations, which is mandatory in the European Union. This platform is multilingual, but also only in the 23 languages of the European Union. So please bear in mind that you have to use English, for example, if you are coming from Japan. But this is a very, very useful tool for you to register your intellectual property rights if you're trading in the European Union. Yoshinobu, let's say a few words about whether you need a representative
Okay.
as an EU company if you want to register something in Japan.
OK。はい。それでは、日本への出願において気をつける点についてご説明させていただきます。
There are some things we need to keep watch over when applications are made in Japanese. The application must be submitted in Japanese to the JPO.
については、
And as for patents,
範囲図面を英語で出願
there's a system in place to file applications with the specification, claims, and drawings in English.
以内に日本語の翻訳文を提出するということになり
And
ます。
within 1 year and 4 months after that, you will need to submit a Japanese translation.
出願人の方につきまして
For applicants who do not reside in Japan, you must appoint a Japanese agent, so please bear that in mind.
Similar in the EU, you need to, well, for application, for example, at the EU IPO, you don't need a representative just to make an application. But for any proceedings, any further proceeding, you need a representative appointed in the European Economic Area, that is the European Union and Norway, Iceland, Liechtenstein. And it also qualifies if you have an employee in another jurisdiction. Provided that there is a real and effective industrial and provided there is an economic connection. And it's a real effective industrial and commercial establishment. We have a list of representatives who made an application already at the EU IPO, so you can make a search at the EU IPO website. Yoshinobu, I think you still have a few words about territoriality, which is very important.
Yes. はい。はい。この点非常に重要な点になります。
Yes, that's a very important consideration.
属地主的であること
It's important to note that the intellectual property rights are territorial. Depending on the company's strategy, it is important to consider where you're going to register, whether in a country, region, or the world.
する場合、
At the national level, applications are filed with the patent office of each country.
州においては地域レベルで特許は EPO に対して意思を証
At the regional level in Europe, patents are filed with the EPO, while designs and trademarks are filed with the EU
で
IPO.
見ますと、
And
知的所有権機関 WIPO
there is
出
WIPO,
願をすることができますし、また
where you will be able to file
に個別に出願する
internationally, or you will be, of course, file independently.
Also have some advice
Yes,
to companies
yes.
about best practices
Yes.
in Japan.
はい、日本でのベストプラクティスについてこちらにまとめさせていただきました。
Yes, I put it together here on this slide.
毎年数多くの出願がされています。
There are many applications that are filed every year.
商標は16万件、
Approximately 300,000 patents, 160,000 trademark applications, 30,000 design applications filed every year. This reflects the country's strong research and development activities and its well-established intellectual property protection system.
のためには
To conduct business in Japan, it is important to demonstrate a company's strength through intellectual property.
知的財産権を得ること
By obtaining intellectual property rights,
ができます。
the risk of damage caused by counterfeiting can be reduced.
商標権と一緒
At the border,
毎年3万件以上
more than 30,000 seizures per year are made for trademark rights and design rights. It is hence important to understand Japanese rules and business trends.
を出す
Many companies establish branch offices in Japan. We are aware.
ジェトロでは日本での
And last, I would like to say,
探す
JETRO also provides support for finding business partners in Japan.
ご興味あります場合は
So please feel free to contact us if you are interested.
Yes, I think most of the considerations also apply for Japanese companies when they come to Europe. It's very important to establish trusted relationships with local partners and to bear in mind that intellectual property shows good health of your business. So take advantage of it. Yes, we have some information material for everybody who wants to learn more about the local rules. Yoshinobu?
Yes, okay. Yes, yes. So maybe previous slide. You have.
Oh.
Yeah, sorry. Yes.
Oh, yes, sorry, this is for me. So please make sure that you learn yourself or you study the publicly available material, because we have plenty of those. For example, you can get more information about the SME fund on our website. You can also contact the EU or European IP help desk, or you can go to the website of the Japan Patent Office. And yes, Yoshinobu, a few words about the JPO website.
はい。はい。はい。日本の特許庁のホームページからは英語でも
On
情
the
報に触れる
website,
ことができます。
information is also available in English. And here's the link on the upper left-hand corner.
からは
And
リンク
the JPO from on X and also LinkedIn,
というところに
the latest topics are
しております。
provided and also published in quick reads. And to the bottom right-hand corner, it says key features. This section provides
掲載しています。
user-oriented information, including examination timeframes and latest systems, and information is available in English.
It's available in English as well for the European SMEs. This is another example of wonderful guidebooks that the JPO produced in English. Here's a link to the frequently asked questions at the EU IPO website as well. We only work with the 23 European Union languages, but I'm sure you will find it useful. And here's some more information resource. For example, the ID5 website, which is the collaboration of the 5 biggest design offices, not just Japan and the EU IPO, but also the Chinese IP office, the US IP office, and the Korean IP office is partner to this collaboration. And we have a design-related collaboration, and we have a website with a lot of useful comparative information. So I advise everybody, not just the business, but also representatives, to study this website. And also the TM5 website, which is the same collaboration of the same offices, but trademarks related. It has a very good up-to-date statistics, so I advise you to check out also this website. And this concludes our presentation. Thank you very much, Yoshinobu. It was a pleasure to have you. Let's see if we have any questions from the audience. I think we made a very clear presentation, so I don't know if Yoshinobu, what is the most frequent question that you get, for example, for Japanese companies who want to do business in Europe?
そうですね。基本的にはヨーロッパでの各社様様々という印象はあります。
Of course, it's varied across the companies.
例えばですね。
But just to give an example,
最新の
the latest
動向であったりとか。
developments in court, in IP litigation, is a matter of interest. And of course, the system differs from country to country. So there are questions about what the differences are. And also, when it comes to counterfeits, how can they cope with counterfeit products in Europe? These are the kind of questions we receive.
Recently, this question from a European company going to Japan because he got scared of the cancellation period, that he had to register his intellectual property, his trademark, for example, and he has to demonstrate use for after 3 years. But then we explained to him that, in fact, it's only if somebody attacks his trademark rights. It's not that the JPO will go and monitor his use. But, for example, the JPO will monitor, for example, if there is an earlier trademark right already registered, and they will not allow your trademark right to register if there is an earlier similar one. It's true that you have this new thing called the consent system, where if you have an earlier right in Japan, an earlier trademark, and if you acquire consent from the earlier owner, then you can file an application. Yes? You don't have to say in detail if you... Yes?
そうですね。日本の最近の新しい制度の改正でコンセント
Yes, there have been amendments in the Japanese system, so we have a consent system. In the past, when it comes to a third party,
商標登録したいというときは、すべての
trademark,
の人から了解をいただかないと。
we needed to receive consent from the same person with the same name. It's been a very strict, rigid system. However,
いただかなくても、
you do not have to receive consent from all the members listed as owners of the trademark.
先行商標を利用している方から
And as your prior trademark
登録できる。
registrant, if consent is given, you can register.
For providing, because it's interesting because it's very different from our practice, and this is something our business European business should bear in mind when they go to Japan, that if the right is taken, they have to talk to the owner of the previous right, because there might be some options to still register if they come to an agreement. I don't see any more questions on the chat, so I think we were very clear about our presentation. Please, if you have any questions, don't hesitate to contact us. We have our email addresses in the last slide, so we are ready to answer any questions you may have. And I would like to thank Yoshinobu very much for coming to Alicante to do this webinar. And thank you everybody for listening.
ありがとうございます。私も機会をいただきましてありがとうございました。ぜひご質問ありましたらメールでいただきたい。
I'm also appreciative of the opportunity that has been given. If there are any questions, please email me. And in reference to Business Partner, if you are interested, please contact us at JETRO. We will be able to help you.
Thank you very much.